All right, we move on to more serious matters, and it is time for legal talk. Today, tackling issues involving living in community schemes, and it's a pleasure to welcome back to the show Zerlinda van Merwe, the co-founder and director of TVDM Consultants. As I always remind you when she's with us, she's got over 20 years of experience in this field, and she has provided legal advice and training to the industry itself, including the Community Schemes Ombuds Service. And she is standing by to tackle your questions around living in communal environments like a sectional title complex, for example. Zerlinda, always lovely to have you on the show. Welcome back.
Hi, Pippa. Nothing more serious than a peppermint crisp tart.
Okay,
now, that's definitely what I'm going to have for dessert.
Okay, I promise I'll take it more seriously next time. Hopefully the neighbours in today's disputes can meet each other over a nice bowl of peppermint crisp tart and make friends again and maybe exchange the recipes. Because, Zerlinda, we've got a couple of questions in from people who are really struggling with issues around their neighbours in sectional title complexes. And it's kind of developed as a bit of a running theme for today's episode. We are happy to take questions on other community schemes issues, but let's start with those questions that came in. And one from Tracy, who writes to say, my tenant moved out because neighbours are making life very difficult for them. The next tenant will most likely also move out because of this difficult neighbour. Is this something the body corporate can deal with? Now, Tracy doesn't specify what specifically the issue is or which behaviour is proving so difficult, but clearly there's something here going on. Tracy, can you refer a neighbourly dispute to the body corporate?
You most certainly can. You know, it's such a big thing in community schemes, in bodies, corporates, homeowners associations, that there is, trouble in paradise between neighbours. And very often when it involves tenants, the issues are not taken seriously by the body corporate, and the responsibility rests on the owner as the landlord and the member of the body corporate. But when it comes to matters that affect sections generally, the building generally, then the body corporate does have to become involved. Of course, when it is neighbour to neighbour, not affecting anybody else, not affecting the body corporate or the members generally, it is a different story. But it is important to note that when it comes to administration issues, for example, conduct law compliance, which is dealing with the noise and the nuisance and all these fun things that we deal with as neighbours, the tenant actually does have a voice. They can make an application at the Community Schemes Ombuds Service for an order involving both the neighbour, the neighbouring owner, the neighbouring tenant, the rental agent, the managing agent, and the body corporate or the homeowners association. So these issues are becoming a lot more rife. What we're finding most often is that tenants are moving out, owners are making claims for loss of rental, which is not something that the CSOs can deal with, unfortunately. And the issues that are being experienced are noise, their harassment, victimization, water ingress problems that don't get sorted out by neighbours or by the body corporates, and just general, I suppose, somewhat discrimination between owners and tenants by bodies corporates as well when it comes to rule enforcement. Perhaps a tenant is not allowed to bring a pet into the scheme, but an owner resident is. So we do deal with a lot of these types of fights on a daily basis, I'm afraid.
Zerlinda, you said the CSOS can't help if the owner wants to make a claim for loss of income. So in other words, I found a good tenant, I've put them in my flat, and now they're moving out specifically because of the difficult neighbour next door. I'm losing my rental income.
Yeah.
If the CSOS can't help there, where would they take that kind of claim?
So that claim would be made against in the small claims court or the magistrate's court, depending on the quantum of the loss of rental. I mean, sometimes we're looking at rather large amounts, breach of contract amounts and things like that. Right. But that is a damages claim, and that's not something that the CSOS deals with. They don't deal with common law delictual claims. When it comes to loss of rental or alternative accommodation, for example, the body corporate not maintaining common property and the section being unfit for habitation, that's something that the insurance policy of the body corporate could perhaps cover. But when it comes to these types of damages claims, nuisance matters between neighbours, unfortunately not something the CSOS can deal with, but claims that do arise very often.
Okay. Tracy, not alone. Manuel's just written in on the WhatsApp line saying, my tenant also moved out due to a very challenging upstairs neighbour, and the body corporate did nothing to help. Now, you mentioned water ingress being one of the common complaints. And Zerlinda, the second question that came in advance of your segment today was from Bernard, who has exactly this issue. Bernard writes, I live in a sectional title complex, and my upstairs neighbour's, it's not water, it's noise from a washing machine. He says, my upstairs neighbour's washing machine causes causes the whole ceiling to vibrate whenever they use it. I've complained several times, but the neighbour says it's not their problem. At what point does the body corporate have to get involved with noise or nuisance issues between neighbours? Sorry, at first reading I thought there was water coming in from the washing machine, but it's actually the noise of the machine rattling on the floor, Zerlinda.
Oh dear, also a nuisance issue, hey? We actually get them quite often, especially in the newer developments. They don't build them like they used to.
Yeah.
When it comes to, sounds between units, upstairs, downstairs, next door neighbors, pipes rattling. We recently had a rattling washing machine, and it was very disruptive in my house, let alone imagining what it would sound like in a sectional title unit. Furniture being pushed around without little moving pads underneath it, or high heels, or stomping around, or playing with a ball. These are all nuisance issues. Normally only experienced owner to owner, or tenant to tenant, or owner tenant, depending on the setup. Not something that the body corporate becomes involved in, but where the noise emanates throughout the building, affects multiple sections, that's when the body corporate becomes involved. I don't think it's right that the owner of the washing machine is saying, hey, it's not my responsibility, you're the one that is suffering the noise. If it is something that is leading somebody to complain, which is a persistent noise, a noise that can be resolved or at least dampened, the person that is causing the noise or allowing the noise to be caused most certainly must do something. They must act reasonably. Of course, we are all different when it comes to, what is considered to be reasonable, what is considered to be a nuisance or a noise. But if it is something that a reasonable person can't be expected to reasonably tolerate any longer, it's affecting your sleep, it's affecting your mental capability to work. Noise can definitely have that type of impact on you over a time. Then it's definitely something that you need to do something about, and the CSOS can make an order in that regard. So if it's not something affecting multiple people, the body corporate not becoming involved, then it's definitely a matter that the two parties can be assisted with at the Community Schemes Ombuds Service, and they'll probably make an order to say that the nuisance must stop, and that the owner of the washing machine, must either have it replaced or must have noise dampening measures put in place, maybe some pads underneath the washing machine, or have it serviced or relocate it. And very often we find that washing machines also do cause a water ingress problem.
Yes.
So funny that you spoke about a water ingress problem. That does happen often too.
I don't underestimate how noisy they can be. And, often it's at the end of a machine's lifespan when it's getting really old and things are loose, it rattles. And I know this from personal experience in my own home with a rattling washing machine in the kitchen, how noisy and intrusive it can be. So, Bernard, I really feel for you. Please do try and push back and tell that neighbour they do actually have a responsibility to do something to mitigate the noise. And if they don't, you can then take further steps. But maybe just try once more to say it really is on you to at least try and dampen the noise. Now, we've got a voice note in from Matt responding to this issue of difficult neighbours, I think. Let's have a listen to what Matt has to say.
Hi, I think this is quite a common problem because me and my girlfriend also just recently moved out of our apartment purely because of the upstairs neighbor, and absolutely no help from the body corporate or anyone. Multiple complaints. It's gone on for months. It literally affected our work because we were unable to sleep at night. We eventually just decided, we had to literally move out. We gave a month's notice and we're leaving at the end of this month. I don't understand. There's obviously a lot of other people that have this very, very similar problem.
I'm so sorry, Matt. Zerlinda, you don't just move out. There are costs involved in moving. There are deposits to be paid on new places. There's all kinds of penalties. It's not a step to be taken lightly.
No, and in Cape Town especially, we're experiencing a housing crisis where there isn't a lot of alternative accommodation or within a person's price range. And when it comes to rental, you can only afford what you can afford. You want to live close to work to reduce expenses, all those fun things. And perhaps you're really enjoying where you're living. You've got children, pets, whatever it might be. So to make that decision to move out because of nuisance or disturbance, I can imagine it is really, really tough. And the greater solution is for people to talk to each other. And that's where that whole community aspect comes in. One of my I think the best things about the introduction of the Community Schemes Ombuds Service was the introduction of that terminology of community schemes as opposed to sectional title schemes or complexes or apartment blocks. you have to think about what does community mean. And when you're speaking about community and the interpretation of community, you're thinking about other people. And unfortunately, we humans are quite selfish, and that we're always going to put our own interests ahead of anybody else's. And if we can just be a bit more tolerant, a little bit more reasonable, I do think that the first step is to engage and to try to put yourself in the other person's shoes. You know, you're not hearing the rattling washing machine or the ball hitting against the wall or whatever it might be, but put yourself in the shoes of the other person and just, you know, push back your own rights to give their rights a little bit of a place as well. It's all about that balancing of rights. Much easier said than done, which is why the community schemes is there to actually make, or community schemes rather, Ombuds Service rather, is there to actually make that determination when we as humans aren't able to come to that outcome ourselves.
Yeah. Now, Paula is asking on the WhatsApp about the effectiveness of lodging a CSOS complaint. We often hear you say this is not something that's within the purview of CSOS, or you've got to go to court, etc. But when you do bring a case to the CSOS that is within their purview, Zerlinda, do you want to talk to the effectiveness of the body?
Yeah, so it's up and down, unfortunately. I really do find that if you know what you're doing when you're making the application and you're running through the process and you're following up and you're speaking to the right people and you know the right questions to ask, you know the right processes, it definitely is a bigger likelihood of success. Once you get that CSOS order, I'm afraid, you know, if you don't like it, you only have the opportunity of either abiding by it or taking it on appeal or review. So it really is up to you as the applicant and the respondent to ensure that you understand the CSOS process and really make the CSOS process work for you. I do find that the processes are improving, especially if you know what you're doing and you're sticking to it and you know following up and really keeping you know it's hot on your side. But if you're simply going to make the application and sit back or make a poor application without real thought, it's going to be a disastrous impact. I find that when you make the application, the CSOS deal with it quite quickly to send it to the other side for reply. They deal with it quite quickly to send it to conciliation, for conciliation to be held, and then for referral to an adjudicator. But the adjudicators are still quite backlogged. They are making big strides in bringing their numbers down, their backlog down, but it is taking some time still to get orders. But if a matter is urgent, then it can be dealt with a lot quicker, of course, if it falls within one of those grounds of urgency. But of course, unfortunately, nuisance doesn't, unless you're getting locked out of your scheme or something along those lines, although water or electricity is getting switched off.
Right.
But the rest, you have to go through the normal process.
Okay, so you've said the importance of putting together a well sort of structured complaint, and a follow-up question from Paula is, where do we find information on how to do that? For a layperson who doesn't sort of know the ins and outs of the scheme, do you need to seek legal help, Zerlinda, or is there a website that guides you through the process? Where can you find advice?
Yeah, so you definitely don't have to seek legal advice. Of course, if you feel like that is something that you need to do, then there are many people that would be able to assist. I mean, it's a service that TVDM Consultants offer as well. We've got a lot of resources on our website, you know, free blog posts and webinar recordings and checklists and all those fun things that you can look at. But you can also find a lot of information on the Community Schemes Ombuds Service website as well. An FAQ of the process, the application form, how to fill it in, and all those fun things. We're finding that people are becoming a lot more confident in making applications and simply sending it to us to review and to tweak. But you know, it really depends on how strong you are in your principles of actually making an application, what your motivation is, you know, what your skill set is, what your time ability is as well in making an application. We find that most often it's the body's corporates and the representative of the body's corporates that are seeking assistance as opposed to the individual owner, because the individual owner or tenant is obviously wanting to keep their costs down. So you don't run off to an attorney if you don't have the budget for it. And I don't think the normal person has a budget for legal fees, whereas the body's corporates and HAs do.
Okay, so while we're talking about it, Paula, the CSOS website is csos.org.za. And as Zerlinda's just said, there are also resources on her website, tvdconsultants.com, if you want to start there. A follow-up question from one of our listeners asking, how can a CSOS order be enforced? Are they enforceable? First question, Zerlinda.
Yes, 100%. They're enforceable. If the parties are not going to adhere to the CSOS order the moment that it gets handed down from the Community Schemes Ombuds Service, it can be made an order of court, either the Magistrates Court or the High Court, and then it gets enforced the same way as a court order. And if the enforcement order is not adhered to, then contempt of court would be the next step. So it really is quite serious business.
That's quite an expensive process to go through, I would imagine, though. So if you have a neighbour who's received a ruling they don't like and is ignoring it, Zerlinda, is it you who has to then cover the costs of taking it through those additional legal processes?
Yes, yeah. So you have to go to court. You don't have to go and sit in front of a magistrate or judge, fortunately. You just need to go to the registrar or the clerks to actually have it stamped, and then the sheriff to have it served, or service yourself. But if it does go the route of still not being adhered to, even though it's enforced as a court order, then you would need to go and appoint a litigation attorney and go to court and all those fun things, and then it can most certainly become quite costly.
Okay, big thank you. Follow up from Paula saying this is very useful information. Paula, thanks. I'm glad it's been helpful, and good luck with your issue. Let's go to a voice note that has come in from our listener Vera, and it's not to do with neighbours, but rather with the body corporate itself, I think. Let's take a listen.
Hey, Pippa, I'd love to know how legal it is for a body corporate or estate management or whichever they're called to take photos from the street into your exclusive use yard and of your patio and balcony, and then give you a fine based on having braaiwood sitting on your patio, or for your lawn being a little bit longer than what they would like.
Okay, Zerlinda, your response?
Well, it's becoming into summer. It's braaiwood season, I'm afraid. So we're going to have these in gardens. As long as the photographs are obviously not infringing on your privacy, you're not, staring into somebody's bedroom or bathroom. It is something that a lot of bodies corporates do or HAs do for rule compliance. They need to record evidence. I mean, even when you have a noise complaint, you need to record evidence. If somebody's having a party and it's against the rules, maybe the security guard reports it in his OB book or whatever it might be. So taking photographs of conduct rule violations is the norm. It is what those photographs are used for, how it is processed, how it is stored, how it is shared. That is obviously a little bit more problematic, especially when it includes personal information, which is a little bit more difficult in these situations. Maybe you're looking at a motor vehicle and their license plate has been taken off on a photograph or a camera recording in a rule breach. But it is normal. From the voice note, it sounds like the person is quite irritated that, that these photographs have been taken and their grass was a little bit longer. But if it is a breach of the conduct rules, then the trustees or the manager, whoever it might be, does have the right to actually enforce those rules. And as part of the rule enforcement, that inspection process is the norm.
Okay, thank you for that. Anonymous asking, what is the best course of action for an owner in a small sectional title scheme who refuses to pay levies?
Oh, happens so often.
Oh, yes.
So in a smaller sectional title scheme, the impact of an owner not paying levies is a lot greater than in the larger schemes, especially when, the body corporate is budgeting, just on its bare bones. All the owners are going to have to, chip in because of this one owner's non-compliance. Going the court route is still the route that the majority of bodies corporates are following, but you can make an application to the CSOS. You can attach a rental. If the property is rented out, you can even attach a person's wages or salary as well. Levies are a statutory requirement. You need to raise interest. You need to pursue it quite quickly. You need to enter into payment arrangements if reasonable. It could go as far as getting a court order to disconnect services. So it can be quite severe, but a body corporate that is smaller and doesn't have a little bit of runway has to, attack the problem quite quickly. Also knowing that if the unit gets sold, either in sale and execution or private treaty, at the end of the day, the body corporate will get its monies back by not issuing the levy clearance certificate. But unfortunately, that's not going to help if the problem is right now. That's a much later issue, a later recourse. So the body corporate is going to have to decide, are we going to go the CSOS route, are we going to go the court route? And then if you go the court route, the issue of legal fees is something you have to take into consideration as well. So you're basically throwing good money after bad. Not a great situation at all.
And an unhappy note on which to end the segment, but a very useful segment it has been. Zerlinda, as always, thank you so much for your time this afternoon and for joining us on the show.
Awesome. Thanks so much, Pippa, and thanks to Maxine. Keep well.
Thank you. You too. Zerlinda van der Merwe of TVDM Consultants. So if you want to check out their website for some of those resources she mentioned, tvdconsultants.com is the address you're looking for.